Good morning, one and all. Legal research methodology regarding application of common sense in law. An interesting case occurred in Rome about AD 150. When Valerius Nepos had made a bill in which, according to law, he had instituted a certain person his heir and added a number of legacies to various friends, as well as the direction that certain slaves should be emancipated. After a time, however, he changed his mind and struck out the name of the heir. At law, this invalidated the whole will, and the property of the deceased was claimed in the absence of kindred by the treasury. The case came up for the decision before the tribunal of the emperor himself, the great Antoninus, Antoninus Pius. At first sight, there seemed to be no reason for resisting the claim of treasury, but the various parties interested in the will were represented by advocates, and the following discussions is recorded to us. According to Juno, I beg, Lord Emperor, that you will hear me with patience. What is your decision with regard to the legacies? The Emperor said, do you think that if he struck out the names of the heirs, he could have desired the will to stand? Um, Priscanus counsel for Leo says it was only the heirs whose names were struck out. Longinus, Council of Treasury says, no will which does not appoint on heir can be held valid. Next, Priscianus said the testator did actually emancipate some of his slaves and bequeath certain legacies. The emperor commanded everybody to leave the room in order that he might consider the question. When the parties were uh, regimented, he said, this seems to be a case for human interpretation. Who we hold, therefore, that Nepos wished to annul. We hold, therefore, that Nepos wished to annul only those directions which he actually struck out. It is clear from the narrative that the emperor was moved to give his decision by two considerations. He thought that it had been the intention of the testator to remove the name of the instituted heir, but to retain the depositions in respect of the legacies and emancipations too. But there was another point. The enlightened opinion of the time was in favor of liberty. This is the tools of study. In favor of liberty. And the emperor was anxious that the freedmen should not be disappointed. Accordingly, after some hesitation, he resolved to overlook the flaw in the form of the will and to interpret it in the spirit of a human equity. In another characteristic set of cases, ordinary rules were individualized by Roman lawyers on the principle that in case of too vague an indication by the law, parties were to act in regard to each other as befits, that means honorable men. Put inter bonus virus ag variator. This case study gives enlightening to us uh, regarding what we may sum up by saying that equity as a method of judicial discretion is inseparable from the complex and efficient system of law. It is not necessary that it should be exercised by special courts, and it does not disappear when special tribunals of the equity are merged by a comprehensive reform of the judicature. The method will retain its value and will have to be exercised in order to supplement the rigidity of the prospective general rules. In the absence of custom bearing on the point, he ought to decide in conformity with a rule which he would have formulated if he had been a lawgiver. In doing so, he ought to follow the views established with the jurisprudence and legal precedents. We will share other relevant case studies in further classes. Thank you.